Mr. Carrington.
Good morning.
Good morning, Mr. Carrington. Mr. Carrington, criminal dock is not until 9 a.m. So I don't know if you want to stay on for an hour or if you want to just log back in at 9.
The notice that we got from you all says 8.
Yeah, but on Mondays and Tuesdays, the jail can't log in until 9.
What?
Yes, but on the Zoom invite on the email, I put civil dockets at 8 and criminal dockets at 9.
Oh, yes, I see it. Yeah. Okay. Yeah, the secretary told me at 8. Okay.
I'll listen. I've got another case
Okay.
at the same time in another court.
Okay. What
But
court?
I'll log on here first.
Okay. Sounds good,
Thank
Mr.
you.
Carrington. Thank you. You're muted, Judge.
All right. All right. 357 District Court will call its court session for today's docket, Tuesday, March 15, 2022 at 8 o'clock in the morning, starting with civil hearing 2018 DCL 6656. Erica Flores, Franklin Dodd, Mr. Laird, Mr. Ramey.
Your Honor, John Elwood here for the defendants, Franklin Dodd and Sunbelt Transportation.
All right.
Good morning, Judge. Nelda Trevino here on behalf of Robert Perez for the plaintiff, Irma Ortega.
Your Honor, this is a defendant's motion for continuance, and it was agreed to for a 90-day continuance. We have a number of depositions that need to be taken, including both of my clients, the driver of the truck and also the safety manager. And there's several expert witnesses that we both wanted to pose. I believe a couple of medical experts, and there's 2 life care planners involved with the case.
Can you explain to me, Mr. Elwood, why this case is going on 3 years, and that hasn't been done as of yet? That's 3 years that you have been sitting on this. What? Give me a good explanation why.
Your Honor, I know that, this is not an excuse, but I've just picked up the case. I just joined the firm about a month ago. So, but I'll give you my understanding of the history. I know that there were a couple other plaintiffs involved, and there had been some discovery done. The case went to mediation before, and I know that one of the minor plaintiff and one of the other plaintiffs were settled. But you know, there has been some time lapse since the last continuance. And my understanding, it's just been an issue of scheduling between counsel and then the expert witnesses. And that's my understanding of what's occurred since then. But we would be ready to go, Judge, and get these things done and get this thing tried if necessary. But we also think if we could get the discovery completed, there's potential to get the case settled at mediation as well.
And Your Honor, if I could chime in on that, I am also, like Mr. Elwood here, on behalf of the attorney of record for this file is Robert Perez. But I did go over some of the documents, and I believe discovery was just exchanged as late as a Friday. So discovery is still, I believe, ongoing.
Well, I don't doubt that, counsel. I don't doubt that from either one of you. My question continues to be why? Why has this case been pending for 3 years almost, and this is just being done? That's what my question is. This is a lot of delay on this case. I will tell you what, I will continue this case, but I'm going to tell you something. I will not continue it for a super long time, and whatever date I give you, you better be ready to go.
Yes, Judge.
Yes, Your Honor.
Going on, and we gotta get moving. You know, there's some claims here that need to be resolved. I am antsy to go to trial. Just got off the political trail, and I'm ready to go. So, how long are you looking at?
Well, Your Honor, we asked for 90 days in the motion. If the court is inclined to give us, a minimum of 60, I would hope would allow us to get all this done, if that's possible.
90 days, we put them in July. That's for what, 90 days? Move into August. August 5th with the 8th. August 5th for announcements, the 8th for trial. This will not be continued anymore. I am placing that note on the file. No more continuances. You all be ready to go.
Yes, Your Honor.
Yes, Your Honor. Thank you.
Have a good day.
Thank
You
you,
too,
Judge.
Judge.
May I be excused? Thank you.
Have a good day. 2021 DCL 1114, Cameron County versus Brown Star Holding. Ms. Curiel.
Good morning, Your Honor. Ariana Curiel on behalf of the.
Are you in Santa Fe or what?
No, I'm not in Santa Fe. I just need background this morning, but I'm here, Your Honor.
Oh, well, I know you're there, but where are you? That's the question.
Today.
Yeah.
Today. I just didn't want all the fuss from the back interrupted in the court.
But at least you changed the narrative, not like Mr. Kendall had to insist on being at the Supreme Court every time he shows up. What are we doing? This is a special exceptions. This is what my market is on docket. What are we doing in this case?
Your Honor, this is a hearing for the defendants. It's actually a motion for the defendants, and I believe they're on.
Hi, yes, I'm here on behalf of Mr. Montemayor. He's on his way. Actually, he was having car trouble this morning. But he asked me if I could just, be here until let the judge know that we have already entered into a payment agreement with Linebarger, and I guess this was just a technicality. He requested this hearing before we had that payment agreement. So I guess he asked if this could be postponed or if we.
You verify that there's an agreement?
Yes, Your Honor, that is correct. We explained that. He called our office yesterday asking about the hearing. However, he had requested this hearing and the initiation of this lawsuit, and he had not signed a payment arrangement before he filed this request for this hearing. However, he has entered into a payment arrangement. We do still want to monitor it, Your Honor. We were talking about $50,000, but he has paid off some accounts. So I think he's on his way to pay these accounts off. We just need more time. We're not willing to close the case yet, just because it is a substantial amount of money in delinquent taxes for this company, Your Honor. So we would not be opposed to a continuance on this hearing.
How long do you need?
Your Honor, I would say 90 days if Mr. Montemayor's office is also in agreement.
What? What was 90 days earlier? July 25th.
July 25th.
That's 90 days.
Perfect. Thank you.
Thank you.
Thank you.
Ms. Curiel, while I have you, I need to ask a question not regarding this matter.
Yes, Your Honor.
When you have, assume that, you have a piece of property and
Yes.
you say you rented somebody to place a mobile home on there, right? When you go and you assess your taxes, you assess it on the land first, right? And then do you assess taxes on the mobile as a homestead?
Yes, Your Honor. So that the appraisal district assesses the land and the mobile home separately. So they have different account numbers.
So if the mobile home is
If the mobile home is attached, they'll do it with the land.
okay, and if it's not attached,
They'll do it separately. They'll do two account numbers, Your Honor.
does that open to the issue of, well, the trailer is not mine. I own the land, but I let him rented it, and he never moved it out. It's there, but it's not mine.
It's happened, Your Honor. And that's when we get into the issues with the appraisal district, and we just need to do deeper research. And sometimes we do, for example, if we do have different owners or they've sold it off, we have to include everyone just to make sure everybody's receiving notices. But it is an issue. We do include the actual owner for the mobile home if that's the case, if it's just that account number, but we do let the landowners know that this is happening. If that's the appraisal district, Your Honor, we don't do that. But whenever it comes to delinquent taxes, we have faced that.
Okay. So any adjustment, like for example, any argument, any discussion, any presentation, to take the position that, well, I don't own the mobile home. I own the land, but I leased it and the guy quit paying me, but he never moved the damn trailer out. And now they're trying to assess it. If it will never be assessed against the land, whatever the mobile home, whatever, right? If he had a different account and it was being taxed because of a homestead, it would never affect the land. I mean, you would foreclose on the trailer itself, right?
Correct, Your Honor. And we usually do not say this, and I know I'm still on the record, but whenever we do have a building only lawsuit, we usually just take a judgment on it. Unless it's substantial building, we do seize it.
Right.
It's a little different from an actual home foreclosed on.
Ms. Montemayor, we're finished. You can zoom out.
Okay.
We took
Thank
care of
you.
it.
I wasn't sure.
Just make sure you know that you set for July the 25th, right?
25th. Thank you so much, Judge.
You're welcome. Have a good day.
You too.
All right, Ms.
So yes,
Ms. Correa, can I get your direct line? Because I want to look at some paper here and ask you a question about that.
absolutely, Your Honor. It's going to be 956-621-6864, and that's my personal number.
Okay, I'll call you in a bit. Let me finish this, and I'm going to ask you a question about some papers that I got.
Yes, Your Honor.
Thank you.
Thank you, Judge.
Thank you.
Alejandro, criminal docket is not until 9, so I don't know if you want to log back in at 9 o'clock or if you want to wait around.
How are you? Very
So
good.
if you want to wait until 9 or if you want to just log back in at 9.
I think I'll log back.
Okay.
Is it a big one?
We have
1, 2, 3, 4, 5, 6, 7.
well, there's more.
Judge,
So,
how are you, Judge?
Good morning. How are you?
Good, just fine, thank you.
Good.
we have a few, but I don't know how many need of course, an interpreter.
I'll be there at 1 till 9.
Okay, sounds good.
Bye-bye.
Bye. Good morning, DC1. Who do you have there?
Genaro.
Say again?
Martinez Genaro.
Okay, thank you so much.
Yes, ma'am.
DC1, is he the only defendant you have there?
Yes, that is correct.
Okay, thank you. Judge, you want to take care of the one at DC1 right now real quick? It's the motion to reduce bond. You're muted, Judge.
All right. 2021 DCR 1050, Genaro Martinez, Mr. Young.
Yes, sir.
Good morning, Judge.
Good morning.
I'm just checking on the amount of bond currently set. I don't see it set in the inmate list on the Sheriff's Department website. It's often incomplete and
the amount of bond is
unupdated.
$50,000.
50,000. I think that's correct.
Well, that's what
I
your
think
motion says, and that's what my paperwork says.
Right. Okay. Thank you. Initially, there was no bond set, but Your Honor had set that bond, and I'm here before you this morning seeking a reduction of that bond. This case, Judge, is a failure to register case. He has another case, 2021 DCR 2746, and I bring that up because certainly Your Honor will be interested in the totality of the circumstances. briefly on 2021 DCR 2746, which is an allegation of aggravated assault with an alleged victim being his uncle, Mr. Fidencio Torres. Mr. Fidencio Torres is working this morning. I wanted to have him available this morning. He wasn't able to be here. In lieu of that, I filed yesterday an affidavit that he signed yesterday, indicating that in direct contravention of the police reports in that case, that he in fact did not report to the police that Mr. Martinez had threatened him or displayed a knife during the incidents in question in that case, 2021 DCR 2746. Again, bringing up because I know the court wants to know everything that's going on with Mr. Martinez. Mr. Martinez in 2021 DCR 1050, which is the case before you, this is a failure to register case. Judge, on this case, the report reflects that Mr. Martinez is homeless, was homeless when he was released from TDC. This was 2 years TDC.
Yes, sir.
Yeah, I'm not really familiar with the underlying facts, and Mr. Martinez, I appreciate you responding. I'm not going to ask you questions at this point. The judge might, but I'm not at this point. That was a 2-year TDC sentence, if that gives the court some context on the potential nature of the underlying charge leading to his requirement of registration. Report reflecting that he would be a transient offender, homeless, having with the requirement that he register in the Santa Rosa area. In any case, Judge, $50,000 bond is very high for Mr. Martinez. I know the court is serious about its bonds and serious about defendants availing themselves of the jurisdiction of this honorable court. And I know this court is also serious about making sure that bonds are not tools of oppression.
Judge, may I address the court?
May the state address the court when I'm finished.
Well, are you finished, Mr. Young?
No, Judge.
Okay.
Respectfully, thank you. A $50,000 bond is well beyond not only his, but his family's ability to.
What family? You told me he was homeless and transient. What family is coming up to bat for him?
Well, Judge, homelessness
equates
equates to houselessness, and not having a house does not mean he doesn't have a family.
No,
he has a mother.
Mr. Young, temper it down a little bit, please. I did not say that. What I'm saying is, does he have family in Santa Rosa area?
He has family in the Harlingen area.
Okay.
His uncle Fidencio Torres, his mother. These are people who, in this other case, 2746, call the Harlingen Police Department for assistance and not to send him to jail. Of course, the Harlingen Police Department often only knows to send people to jail and not to provide assistance.
Assistance for what? What do they need assistance with?
Mr. Martinez suffers from various physical and mental issues, and at the time in question in 2021 DCR 2746, he was intoxicated. He was arguing and causing some disturbance. He was very depressed because his wife had left him. He's lost a lot.
Okay, so I'm confused. So there was a period of time after he was released that he was homeless, and then he got married, or he was married before he was sent to the penitentiary?
I believe he was married already.
Okay.
Is my understanding. He does have family. They are trying to get him out. He had an episode spurred by a great deal of depression, and according to the Harlingen Police Department, Mr. Torres had reported that he had threatened him with a knife. Mr. Torres has filed an affidavit, which I filed with the court and sent to the state.
Well, I'm not
Where
gonna,
he-
I'm not gonna pass over where they were lying and the police was making this up and that's never occurred. That's not before me. What's before me is the propriety and the amount of bond, whether it's enough to assure the defense appearance in future hearings and or whether it would be a threat to the community. That's my only assessment this morning. I'm not
I
gonna
understand
get
that, Judge.
to the merits of any other problem. But it seems to me that if he's drinking and doing all that, he's not observing his conditions of probation or parole, whatever it may be. So, Mr. Ariola.
Judge, I literally just got off the phone with victim Fidencio Torres 5 minutes ago, and he stated that he's not denying at all whatsoever that the events occurred. The only reason he signed that affidavit of non-prosecution is because he's doing it as a favor to his sister, who is the mother of the defendant, because he felt bad that the defendant is going through medical issues, something about his pancreas. And also my notes indicate that on December 7th, he reached out to my crime victims advocate and stated that he fears for his life, and it's not the first time the defendant threatens him. I literally just got off the phone with Fidencio.
I'm going to object to this. I object to this. I've got a sworn affidavit. I've got a sworn affidavit that we filed yesterday. Now Mr. Ariola is coming in here with, I got off the phone with him yesterday and here's the hearsay.
Okay.
I object to all of
Let's
this.
call him right now at 266.
Then get him on the Zoom. Then get him on the Zoom.
Mr. Young, are you finished?
Let's hear him.
Mr. Young.
And also, Judge, that doesn't, he needs to stick to a story and stay to it. He's saying that Fidencio Torres wants him. Fidencio Torres wants nothing to do with him. And also, if he's homeless, how can we monitor him if he's homeless? We're gonna end up right back at square one. He's gonna go missing. He's gonna go missing in action, and we lose him.
No, I have an address at my mom's. I have an address with my mom. My mom got a 2-bedroom apartment.
What is the necessity of him? Is he got a job or what?
Now I'm doing my SSI right now. That's what I'm filing up for.
He's been in custody for several months.
All right.
I have a real problem, Judge, with the state coming in and saying what Fidencio Torres said when I've got a sworn affidavit that he signed yesterday. A sworn notarized affidavit. And now Mr. Ariola comes in here with, well, I just talked to him and he said this, but he can't be on the Zoom this morning. What is that about? Because he told me that he had to work this morning. And I'm not saying Mr. Ariola is lying to the court, but when I come in here with a sworn affidavit and Mr. Ariola says, well, he told me this and therefore the court should rule this way based on this hearsay, I have a real problem with that.
He wasn't at work, Judge. He informed me he was getting dialysis as we speak.
Dialysis, yes. For whatever reason, he couldn't be here. It was dialysis. That's correct.
Not working. So then you're misinforming the court then?
Oh, for crying out loud. He couldn't be here.
All right,
but he can talk to you.
Are you guys, okay, look, I've got other matters to deal with. I don't have time for you guys to get into it. Mr.
Judge, $50,000 is too high bond. He can't afford it. It's a
Mr. Young, can you stifle it for a second, please? Mr. Ariola, I want to hear from this man. Is there any way you can get him on the phone or get him on the Zoom?
Okay.
It doesn't have to be today. It can be later on today. I'm going to be here this afternoon. So can we do it this afternoon?
Sure. I could call him right now, Judge. He'll answer.
Okay, call him and see if it's possible for him to get on Zoom.
right now.
Because I need his testimony under oath. All right.
And I'm happy with that. That whatever he says, he says. Whatever he says before the court, he says before the court.
All right, just calm down, Mr. Young. Calm down. All right. Can that happen? All right, while he does that, let me call the other ones. 2019 DCR 1116, Jorey Cavazos, Mr. Elizondo.
Hello, Judge. Good morning. Gustavo is only here for Mr. Cavazos.
Okay. Are we ready to proceed on the motion to adjudicate on this one?
Yes, Judge. I don't see him on the screen.
Hold on, Carrizales is bringing up.
Y'all two sit right here, please.
Judge, I was able to get him on the line.
And what do you say? You're muted. You're muted.
You're on speaker. You're on speaker, Mr. Torres. The judge wanted to ask you a few questions.
Okay.
Where are you currently at right now, sir? What procedure are you getting done right now?
Dialysis treatment.
Okay, did we speak? 5 minutes?
I can't, Mr. Aguilar, I can't hear him.
Can you hear him? Did we speak about 5 minutes ago, sir?
Yes.
Okay, I need you to speak a little bit louder. And is it true that you informed me that you're filing that non-affidavit of non-prosecution as a favor for your sister?
Yes.
And why is that?
Well, he's apparently he's been having problems in Tarrant County and been going in and out of the hospital, and my sister's just worried about him and everything. And I don't know.
Okay.
So
you're not denying that that what happened. You're just doing it as a favor for your sister.
Yeah, I'm doing it as a favor. Yeah.
Okay. Any questions, Judge?
Sorry. I have questions.
What's his name?
Fidencio Torres.
Mr. Torres.
Yes.
This is Judge Magallanes.
Yes, sir.
Have you previously complained about this gentleman threatening you?
So what?
Have you previously complained of this gentleman, Mr. Martinez, threatening you?
Yeah.
You have?
Yeah. Yeah.
Is he got something against you, or you all in a fight, or not talking to each other? Why is he got a threat? Why is he have it in for you?
Well, he got drunk and everything, and he was started with my sister, and he went over to my sister went over to the apartment because she was scared of him, and he went over there and started with me, and I told him he better leave, or I'll call the cops on him. That's basically what happened. You know, he was high on crack and beer, and then some girl there gave him some pills, and he was all acting stupid and everything. He normally doesn't do that, but what happened, his wife left him the way he is, and that's what started everything. And he was drinking for almost a whole week. And, you know, he was getting problems with my sister, and on that day he threatened to hit her and everything, and my sister went over there. We lived in the same complex, and I told him he better not go over there and start anything with me, and he went over there and saying a whole bunch of stuff and everything. I just went ahead and called the cops on him.
At that time, did he threaten you with a knife?
Excuse me?
Did he threaten you with a knife at that time?
No. Well, I thought I saw a knife, but he usually carries one. There's a little small pocket knife.
But were you threatened with that small pocket knife?
No. When I went outside, he came over and broke one of my windows, and I went outside, and he was, I don't know, he had a beer can and something else in his hand, so I really didn't, you know, I thought it was a knife, but he usually carries one.
Okay.
So, but when they arrested him, they didn't find anything, so I guess they discarded the knife. So.
Did he threaten you?
Yeah, he said he was going to kick my ass and all that stuff. And I just threw him off. I knew how he was, but, you know.
May I ask a question, Judge?
Yes.
Thank you. Mr. Venancio, this is Jim Young. Good morning.
Yes, yeah,
Mr. Venancio, you and your sister, who is Gennado's mother, were in my office yesterday, were you not?
yeah, yes, sir.
And yesterday, you swore under oath by signing the affidavit that was notarized by our secretary here that in no time did he display a knife or threaten you with a knife in the incident in question, correct?
Yeah.
Do you stand by that? Do you stand by that statement?
Yeah, but I saw that he had a beer can, and I don't know what else he had in can, but you know, I saw a knife, but he's always carried a knife, so that's why I was scared. You know.
But you never saw a knife, correct?
No.
And your sister was here, Gennado's mother, who also said that at no time during that incident did she see a knife. Isn't that correct?
Yeah.
And did he ever wield a beer bottle or beer can in a way that you thought he was going to harm you or somebody else with it?
Well, yeah, because he kind of waved the beer can, and so that way I just went in back into the barn and just called the cops.
Hmm. And when you were here in my office, you guys talked about the fact that, well, that's fine. That's fine, Judge. Thank you.
All right. All right. Is that it? Thank you, Mr. Torres.
Thank you, Mr. Torres.
All right. The motion will be respectfully denied.
Thank you, Judge.
Thank you.
Judge, I want to thank the court for hearing me this morning.
All right, sir. You have a good day, Mr. Young.
Thank you, you too. Thank you, Mr. Abriola.
We're going to do Mr. Cavazos now, Judge.
Yes.
Mr. Cavazos, please raise your right hand. Do you solemnly swear from the testimony given will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Put your hand down.
All right, this is cause number 2019 DCR 11-16E, the state of Texas versus Jerry Cavazos. Is that your true name?
Yes, sir.
Are you the same Jerry Cavazos that on November 5th, 2020, pled guilty to the offense of possession of a controlled substance, and you were placed on 1 year deferred adjudication probation? Is that you?
Yes, sir.
All right, you're represented here today by Mr. Elizondo, is that correct?
Yes, sir.
Mr. Elizondo, do you waive formal reading of the state's motion to adjudicate Mr. Cavazos' guilt?
Yes, Your Honor, we waive a formal reading.
Do you find Mr. Cavazos competent and able to assist in all matters?
I do, Your Honor.
All right, Mr. Cavazos, since you last were before me, has another judge like me declared you mentally incompetent?
What was that, Your Honor?
Okay, listen up. Has another judge like me, since I last saw you, has he declared you mentally incompetent?
Oh, no, sir.
All right. Have you had an opportunity to go over the allegations contained in the state's motion to adjudicate your guilt with Mr. Elizondo?
Yes, sir.
After having done so, do you feel you understand what's being alleged as a basis to adjudicate your guilt?
Yes, sir.
Okay, and I now ask you, how do you wish to plead to the state's motion to adjudicate your guilt? The allegations contained therein, are they true or not true?
They're true, Your Honor.
All right. Are you aware that on your plea of truly no reasonable probability, I will find the allegations in the state's motion to adjudicate to be true, and in all reasonable probability, I will find you guilty of the offense of possession of a controlled substance? Are you aware of that?
Yes, sir.
Are you pleading true because the allegations contained in the state's motion are true and for no other reason, Mr. Cavazos?
No, sir.
Are you pleading true because the allegations contained in the state's motion are true and for no other reason?
Oh, yes, sir. I'm sorry.
All right. Has anyone threatened you, promised you anything, or placed you under any fear of any kind to force you to enter a plea of true before me today?
No, sir.
You understand that by pleading true, you're giving up your constitutional right to confront the witnesses, the right to have them appear in person, and the right to have your attorney cross-examine them. Are you aware you're giving up that right?
Yes, sir.
Right. Is there a plea agreement in this case?
No, Your Honor, there's not.
All right. The court will take judicial notice of all documents on file based on your plea of true. I find there is sufficient evidence to support the allegation of state's motion to adjudicate, and I hereby find you guilty of the offense of possession of a controlled substance. How long has Mr. Cavazos been in jail?
Your Honor, it's been about a week. And Judge, we have a request for the court. We have my client's mother and aunt here to address the court as well.
Okay. Yes,
Judge,
ma'am. Who do I hear from first?
the mother, Judge.
She's a little.
Sure. Actually, the aunt, Judge, the mom's under a little bit distressed.
Mr. Elizondo, I'd love to see your mug as much as you want to show it to me. But I like to have mother closer to the screen so I can hear what she's saying.
Yes, Judge, I'll have her sit in this seat.
Thank you.
Okay. Ma'am, go ahead.
I know, but well, he can't see me, he just can see you, so camera.
I don't want me to swear her in or anything, Judge.
No.
It's good in your right there. See it?
Good morning.
Good morning, Your Honor. My name is.
Your name? Your name?
Cynthia Sarabia.
Good morning, Ms. Araya.
Good morning, Judge. I am Jerry Ray's aunt. His mother's with us as well, but right now she's a little emotional. And we would like to speak to you on behalf of my nephew.
Sure.
I know that he's messed up. He was on probation. During that time, it was a very low point in his life. No excuses made. I'm an educator. I work with students and troubled students. When my nephew messed up by not showing up to probation, not being compliant, he wasn't working at the time. He was at home. The pandemic had happened. And there was a lot of confusion as far as as far as his probation. What we're asking is that if he is on probation, this time his mother and I are going to be on top of him. We are going to make sure that he does pay the fines he has to pay, show up for his appointments that he needs to show up for. Not that we're making excuses for him, but right now, Judge, he does have a good job. He's working the oil refineries. He's been very responsible. It's in Corpus. So he works 10 to 12-hour shifts daily. They do drug tests, and he's been showing some progress, Judge. Maybe college is not in his future, but this job is a good job. It's a good paying job. He's showing responsibility. We don't want to take that away from him. Taking that away from him, Judge, is not going to help him at all. We want him to continue working. We want him to continue with this job. If he is on probation, we're going to make sure that he does everything he has to do. It's very hard to force somebody to do something when they don't want to, but Judge, this is serious. And, I think he's seen how far this went. So what his mother and I want to ask is if you can please give him the opportunity to continue on probation, give him the opportunity to continue with the job that he's working at now. Let's not take that away from him. Let's not set him up for failure. Let's, give him a chance to succeed, give him a chance to do,
I agree with you. I agree with you, Ms. Sarabia. The court's endeavor has always been not to be stern just for the sake of being stern. It's always been the endeavor to try to recapture some of our youth. I try to give them as many opportunities as I can, but there comes a point where there's a point of diminishing returns. There's absolutely no effort. There's continued violation of laws. There's continued non-compliance with, what would you and I would assume to be just cakewalks, walks in the park. They seem to find a way to complicate such a simple act. And maybe it's because of their immaturity. Maybe it's because of at this young life, when they're hit with those life changes, some of them can bear it and some of them can walk right through them and some of them falter. And maybe he's one of those that's faltered. I understand that. But you have to also understand you're part of the community, you and his mom. And you have to understand that there's an obligation on this court to also watch out for the community as a whole. If I have him out there continuing to ignore and in a blatant way, the consequences of his actions to begin with, in such a way that he continues to violate the law. If he was a matter of not reporting, not paying his fees, things like that, well, at least I can, but when they start taking that extra step of violating the law, getting arrested again, then to me, it signals that there's a bigger problem here that I may not be able to handle through another opportunity, because they'll never get it. I don't know if your nephew is one of those. I can only take comfort in the fact that you will have assessed him because you and his mom know him a lot better than I ever will. That's for sure. And if your assessment is that, he has learned, that he understands now and what have you, that this is a serious matter, that the court's expectations on compliance are 100% on him, on his back. That is his quid pro quo, as they say in Latin, something for something, right?
Yes.
You got in law, you violated the law, you want an opportunity to show this is not you, then you have to comply with certain obligations. That's the quid pro quo. You want your freedom, you do it in return for this.
Mhm.
And so our justice system is structured that way. My discretion to have placed him on deferred adjudication on the first place is exactly that, discretion. I took a chance because the law says I could have sent him to the jail immediately. There is no requirement that I give him probation. Those are all discretionary matters. And I used my discretion to place him on probation. Disappointed am I? Yes. As well as probably both of you in him. I want to believe that your soliloquy that you just gave me is a fair assessment of where he's at. I want to believe that. What I'm going to do is I'm going to undo what I just did. I'm going to take back the conviction. I'm not going to nail him with a conviction. Go on his record. They will go on his record so that you will understand the magnitude of the second opportunity that I'm going to give you. So you and his mom, what is his mom's name?
Please, Lisa,
Come on up here, ma'am. You need to hear this. I'm going to, you're Ms. Cavazos?
Yes, sir.
I'm going to undo what I just did because of the presentation and the comments made by your sister, I would imagine.
Yes.
Because I'm going to believe that you are in a better position to assess what, if any, impact this has done on him and what is he ready to do. I do not cherish the notion of strapping a young person with a conviction on his record because I know how damaging that can be. That's why I placed him on deferred adjudication to begin with, which meant if he complied with that, this thing would have been like dismissed a long time ago. But again, a seemingly easy step for you and me to take has been a torture step for him to take. He's tortured the hell out of it. When he could have just walked straight for 1 year and this would have been behind his back and gone. No conviction, doing whatever he's doing, earning a living, walking around free, not turning around, watching his back, hoping that one day somebody's going to pick him up. Nothing like that. It was totally put in his young hands. But then again, I'm mindful that when you're young, todo se te hace fácil. Right?
Yes.
Because you don't see any tomorrow. So the court is going to reverse the judgment and made is not going to find him guilty of possession of controlled substance. Miss, who is on probation? Who is the probation officer in this one?
Your Honor, Sylvia Atkinson with probation.
Ms. Atkinson, have we?
Yes, sir.
We have extended this before?
No, Your Honor, but I do want to let the court know that he has 4 pending cases in Hidalgo County that are set for hearing on March 24th at 8:30. The first one's for a DWI, possession of marijuana, and then a striking a vehicle, unattended vehicle, and driving while license invalid with previous convictions. Those are all set for March 24th at 8:30 in Hidalgo County, Judge.
All right. Well, then I want to reset this until after that. I want to figure out what Hidalgo County's going to do with it. They got him on much more heavy stuff than I do.
Yes, Your Honor. And well, he was also classified as an absconder previously to being picked up 10 days ago.
Yeah. So he's got a host of problems, Miss Cavazos. At least that's the one he's got with me. He's got other music to face in Hidalgo County.
Yes, he's on top of that, Your Honor. He has, his attorney is working on that, the one that's representing him, he has all of that. He combined them all. So Ray is already like working on that with his attorney.
Do you understand why the disappointment now? Not only he did not report, but he's out committing crimes. You know, how would I have looked if he had a DWI and combined the striking a fixed object together and struck somebody? How would you feel? How would I feel? How would I feel if he killed somebody? So these are all very serious consequences. He might not think so.
Yes, sir. They are major.
Well, I'm going to reset this motion. I'm not going to take any action. I'm going to reverse everything I've done, and I want to look at it with a fresh pair of eyes after he gets through with his problem in Hidalgo County. We'll see what they do over there, because if whatever they do there, this could be a foregone conclusion too. Do you understand what I'm saying?
Yes.
If he gets time over there, like for the DWI, then, you know, whatever I was trying to do here ain't going to work. He's already going to be serving time. You understand me?
Yes.
All right. Mr. Elizondo.
Yes, Your Honor.
I want to ask you just to monitor what's going on in Hidalgo County in terms of whether this 24th hearing is going to happen and what was the result of that.
Yes, Your Honor.
And also, Ms.
I'll
Atkinson,
contact
Ms.
the attorney.
Atkinson probably have a direct pipeline over there to know what's going on over there, right, Ms. Atkinson?
I'm sorry, Judge?
You have a direct pipeline to be able to tell me what's going on with the disposition of this case in Hidalgo County?
Yes, Your Honor, I will call the county clerks and follow up on the 24th. See the disposition of the cases, Judge.
All right, so then we'll reset this for the latter week after the 24th. Ms. Sala? No, after that. No, give me a little bit longer. There's no more days in March? One in Galveston? How about the 26th? Well, he's in jail. I only have Monday and Tuesdays in the jail. Oh, okay. Well, that can't happen. All right, we'll set it for the 25th, the following day. See what happens.
Your Honor, I don't know if they're going to transport him. It's going to take time to transport him to Hidalgo and then bring him back. I don't know what they're going to do. I'm not sure if Hidalgo County knows And he's in custody here in Cameron County though.
His attorney knows that he's here, Judge. He's out on bond on Hidalgo cases. So I can get with them, Judge. Would the court entertain a bond between now and the 25th, Judge?
We'll take care of it.
Well, why would I, Mr. Elizondo? He has not earned my trust that I'm going to release him and he's gonna stop this. If I release him, he's gonna go do it again.
Can I talk to you?
You know, might be shaking his head and all that, but you know, that's the whole thing. I don't want him running a risk that he's gonna again get in a car drinking and stuff and go kill somebody.
May I speak, Your Honor? Like I said, like you know, back then I was making the wrong choices, you know, like not being responsible. And I could promise you, sir, I'm gonna do it right this time. Like I promise you with everything, sir. Like I've learned my lesson. I've been here. Like jail is not the place.
You have absconded from probation. You've continued to commit crimes. Why should I trust what you say, Mr.
Mr. Judge, this was like a while back, Your Honor. Like this was a while back. Like if you look from like what I've done in the past 6 months, like I've been good, Your Honor. Like I've been working, I've been doing good. I could promise you with everything, Your Honor. Like I'm gonna do it right, Your Honor. I promise you.
Right, but you were working everything, but you forgot you were on probation?
No, I didn't forget, Your Honor. It's just I had been like working like 7/12s. Like I didn't even have time. I didn't even come to the valley because I had just been working so much. And like, I'm not gonna lie, I kind of like brushed it under the water, not being responsible. But I could assure you, Your Honor, like I will really do it this time. I promise you with everything.
Your Honor, I'm sorry, excuse me. I'm not undermining you, but what my nephew says is true. He has, during the time of those offenses that he had, Your Honor, it all happened during the same, if you look at the dates, they're all pretty much like within months of each other. And he was, you know, with a lot of time on his hands at the time. He wasn't working. His mother and I were not aware of, you know, the probation and what he had to do. Now we are involved. His mother and I, if you want us to follow up with you, I know you asked the probation officer.
The problem that I have is that he's going to return to work in Corpus. You guys are not in Corpus.
But
so again, and we're going to have to leave him to his own device. And therein lies a rub.
No,
so far he's proven that under his own devices is a disaster.
No, I could assure you, Your Honor, like
I know you're assuring me left and right and that this time you mean it and this time you'll do it. I understand that. Don't plead with me anymore like that because I understand that's what's going to come out of your mouth because you're in this pickle now, which a pickle you could have avoided. And we've talked about that.
Yes, sir.
So don't tell me any more promises. I promise you I will. I don't because I've seen disappointment in that stage too.
I understand.
So people swear up and down. Oh, if you do it one more time, Judge, I would know. I promise I screwed up. I didn't know. I mean, well, I was going through depression. My girlfriend's mother died and I got depressed along with her. And I've heard it all, Mr. Cavazos. I've heard it all. So your pleas are just part and parcel of a recording. Because that's exactly what you have to say.
Yes, sir.
But here's the other thing. Here's the thing that I need you to be more mindful about this morning. You look at the screen where your lawyer's at. Look at the background over there. What do you see? What do you see?
My mom, Your Honor. And
your mother doesn't owe me anything. You are the one that owes me everything. Your mother has no business being dragged into court like this, tearfully crying for your behalf. No need. You are torturing not only you, but you're torturing your family. And I want to believe that you haven't lost all humanity and you have some semblance of love for that lady. That you have some semblance of love and respect for her. Que te ha quedado un poco. Because that's what you have to draw on, Mr. Cavazos, from here on. You take a look at your mom and you take a look at her face when she came on the screen and be influenced by that picture at every time that you want to go screw it up again. When you want to get in that car with your friends You have no friends other than those two people that are sitting right there and your lawyers there. Those are your friends. The ones you find on the street are not your friends. That you will find that they're the first ones that run for cover and leave you there. You have to understand that that is life. That's why people ask you to be close to your loved ones, close to your family, because you get in a pickle, when you get in a bind, your friends are not going to come to jail to take you out. They're not going to come to court to plead with a judge. It's your parents, it's your mother, it's your aunts, it's your uncles. People that genuinely love and care for you. You need to return some of that. And you know how you can do it? With your conduct. With your conduct. That's all they ask, your conduct. This is not who they raised. Your mother didn't raise you this way. Give her something back.
Sir.
The court will grant him a PR bond, leave this matter pending for the 25th, so he can go try to take care of that matter in Hidalgo County. I will give him under supervision not only of probation, but of his parents, his mom, and his aunt. They will hopefully keep a close eye on him and remind him of this conversation this morning, and remind him of the pleas he made to me, and remind me of the promises he made to me to comply and to behave. Because if you get into another problem between the other hearing, you've signaled me where you want to go.
Sir.
You understand that?
Yes, sir.
All right. Thank you.
Your Honor.
Thank you.
So you're granting a PR bond. Can he be admonished that he contact the probation department upon his release and before leaving to wherever he's working? Because he also violated that condition of probation by leaving the county without permission.
Part of your conditions, and if you don't know, remember them, you need to contact your probation officer. That wouldn't be you, right, Ms. Atkinson?
Yes, it is, Your Honor. Me.
Okay.
I'm back on case level.
What? Okay. Your number, please, current, where the probation is gonna find you 24/7. What is it?
Well, I don't have my phone right now, but my number to get to my mother is 956 360 6385.
I'm sorry. Your Honor, we're seeing people right now, so if he, upon his release, can he contact me at 361-8300?
361-8300, Mr. Elizondo.
Yes, Your Honor.
Yes, Your Honor.
And what was his contact number?
956 360 6385.
That's right. That's correct.
All right.
And I'm currently in San Benito, in the San Benito office.
All right. Mr. Elizondo, you got that?
Yes, Judge. And Ms. Atkinson, I'll have them reach out to you as soon as he gets out. They'll go see you and call you.
Thank you.
Do that, because then if you don't, you already started wrong.
Yes, sir.
All right. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
All right. I'll give some time to get the pleas ready. I think we have 3 of them. Are they ready?
No.
Okay.
County Jail, who do you have there?
Good morning. This is number 5, Rodriguez David.
David Rodriguez, thank you so much. Carizales, who do you all have there? Good morning. Who do you have? What defendants do you have, Carizales?
I have number 7 on the docket, Ms. Garcia Dora.
Okay. Do you know where Mr. Redner is by chance?
Yes, I have him on the bench as well.
Okay, and we have to keep him separate, correct?
Yes.
Okay, thank you. Can we have Mr. Redner then? Do you want to go ahead and prove up Mr. Rodriguez's paperwork? Sorry, I don't know your name. No, I'm sorry. I'm talking to the clerk. I don't know your name now. I'm sorry.
Sam.
Okay, Sam, if you can go ahead and prove Mr. Rodriguez first.
Oh, okay. Okay, Mr. David Rodriguez.
Yes, ma'am.
Has your attorney thoroughly explained these documents to you?
Yes, ma'am.
Do you have any questions for your attorney at this time?
No.
Okay, and can you confirm that this is your signature?
Yes, ma'am.
Okay, thank you.
And then we have Mr. Redner on the screen as well.
Mr. Stephen Redner? Mr. Stephen Redner,
Yes, ma'am.
has your attorney thoroughly explained these documents to you?
Yes, ma'am.
Do you have any questions for your attorney at this time?
No, ma'am.
Okay, and can you confirm that this is your signature?
Yes, ma'am.
Thank you, sir.
There's nobody there. Hey, can you tell me if I have?
Mr. Rodriguez and Mr. Redner, please raise your right hands. Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth? Help you God.
Yes.
Thank you. Y'all can put your hands down.
Who's representing David Rodriguez?
It's Mr. Carrington.
Good morning, Judge.
Morning. What is he pleading guilty to, Mr. Carrington?
I don't think he heard you, Judge.
What is he pleading guilty to, Mr. Carrington?
Pardon, Judge, I couldn't hear you.
What's he pleading guilty to?
He's pleading guilty to burglary of a building, Judge. It's 12 misdemeanor punishment, 1244A.
Okay. What is
It's count one of the indictment.
Redner pleading guilty to?
To a possession control substance, Judge. It was a state jail felony, but it's being played as a 1244A.
All right. This is cause number 2021 DCR 3044, State of Texas, David Rodriguez. Is that your true and correct name, sir?
Yes, sir.
All right. And also, this is cause number 2022 DCR 259, State of Texas versus Stephen Wayne Radner. Is that your true and correct name, sir?
Yes, sir.
Both of you are in front of me because your attorneys have told me that you wish to enter pleas of guilt to respective charges in the indictment. In your case, Mr. Rodriguez, you understand you're pleading guilty to a burglary of a building,
Yes, sir.
punishable as a state jail felony reduced to a Class A misdemeanor, which calls for confinement in a county jail for a term of up to 1 year. In addition, I can impose a fine not to exceed $4,000. Are you aware of that?
Yes, sir.
Are you doing this freely and voluntarily?
Yes, sir.
All right. Mr. Radner, you're pleading guilty to possession of controlled substance. Do you understand that?
Yes, sir.
And in your case, it's been reduced to a state jail felony punishable as a Class A misdemeanor, also under Penal Section 1244A, which calls for confinement in county jail for a term of up to 1 year. In addition, I can impose a fine not to exceed $4,000. Are you aware of that?
Yes, sir.
All right. Is it necessary to rearraign either Mr. Rodriguez or Mr. Radner?
No, Your Honor. As per Mr. Redner.
Mr. Carrington?
Yes, Judge.
Is it necessary to rearraign Mr. Rodriguez?
I'm sorry, Judge, I couldn't hear you.
Is it necessary to rearraign Mr. Rodriguez?
Oh, no, Judge.
All right. Mr. Rodriguez, understanding what you're pleading guilty to, understanding what the range of punishment, I now ask you in cause number 2021 DCR 3044, what is your plea to the charges of burglary of a building reduced to a state jail felony punishable as a Class A misdemeanor? Guilty or not guilty?
Guilty.
All right. Mr. Radner, understanding what you're pleading guilty to, which is possession of a controlled substance reduced to a Class A misdemeanor under Penal Code Section 1244A. What is your plea to such charges of possession of a controlled substance? Guilty or not guilty?
Guilty, sir.
Are you both citizens of the United States, Mr. Rodriguez?
Yes, sir.
Mr. Radner?
Yes, sir.
Are you both pleading guilty because you're in fact guilty and for no other reason? Mr. Rodriguez?
Yes, sir.
Mr. Radner?
Yes, sir.
Are either one of you pleading guilty out of any persuasion of fear, hope of pardon, force, threats, or promises of any kind? Mr. Rodriguez?
Yes, sir.
Mr. Radner?
No, sir.
Has either one of you ever been in a mental hospital treated by a doctor for any mental disorders? Mr. Rodriguez?
No, sir.
Mr. Radner?
No, sir.
All right. What is the plea agreement in this case? In Rodriguez?
Judge, on Mr. Rodriguez, it's 8 months in county jail, credit for time served. Although the plea bargain doesn't reflect that it's credit for time served, that is the agreement. It was inadvertently left off, Judge.
All right. What about with Mr. Radner?
Judge, the plea agreement is 1 year county jail credit for time served under 1244A.
The court will now go through the admonishments regarding rejection of a recommended sentence. The court is inclined to accept the recommended sentences. I'll find that the court find that the plea of guilt of both Mr. Rodriguez and Mr. Redner were freely and voluntarily made, and they're both competent to stand trial. Ask the state to produce evidence to substantiate the plea in state of Texas versus David Rodriguez.
State offers 1, 2, and 3. State offers 1, 2, and 3, Judge.
Carrington, are you having trouble hearing everybody or what?
No objection, Judge.
Okay. Also, I ask the state to produce evidence to substantiate the plea in state of Texas versus Steve Wade and Radner.
State offers 1, 2, and 3.
No objection, Judge.
All right. Both of you, Mr. Radner and Mr. Rodriguez, have executed a set of documents like this. These are yours, Mr. Rodriguez. All these documents are related to your case, the one you're pleading guilty to this morning. Mr. Radner, you have one too. And both of these set of documents are known as plea packets. And the plea packets in each one of your cases consist of 3 exhibits. And exhibit number 1 in your case, Mr. Rodriguez, is a 9-page document. And on page 7 of the exhibit, there's a signature line. There's a signature already on there. Is this in fact your signature, Mr. Rodriguez?
Yes, sir.
All right. Likewise with you, Mr. Redner, your plea packet consists of 3 exhibits. Exhibit number 1 consists of 9 pages, and on page 7, there's a signature line. There's a signature already there. I want to confirm, is this in fact your signature, Mr. Redner?
Yes, sir.
All right. Both of you, do you understand, both of you, that in these documents, you have waived, given up your constitutional rights to a jury trial, your right to remain silent, your right not to incriminate yourself, and your right to confront your accusers? Are you aware of that, Mr. Rodriguez?
Yes, sir.
Are you aware of that, Mr. Ratner?
Yes, sir.
Further, with respect to both of you, and with respect to exhibits 2 and 3 attached to your respective plea packets, are you aware that you have agreed and stipulated with the prosecution that exhibits 2 and 3 are true and correct copies of the incident reports, the arrest reports, the lab reports that were generated as a result of your respective arrests, the reason you're pleading guilty to me this morning? Is that in fact your stipulated agreement, Mr. Rodriguez?
Yes, sir.
Mr. Ratner?
Yes, sir.
All right. In that case, I'm going to find that you both have voluntarily and intelligently waived your constitutional and statutory rights, and the evidence offered by the state does substantiate your plea of guilt. And accordingly, the court will find Mr. Rodriguez guilty of burglary of a building. And having signaled that the court will accept the plea agreement, hereby sentences Mr. Rodriguez to 8 months confinement in county jail, credit for time served under 1244A. Anything else, Mr. Carrington?
Nothing from me, Judge.
All right.
He had been in jail 133 days up to this point, Judge.
Whatever his credit is, I've given him credit for time served.
Yes, Judge.
Thank you. All right, Mr. Ratner. Having previously found you guilty of possession of a controlled substance, as pled to, the court hereby sentences you to 1 year confinement in county jail, credit for time served under 1244A. Anything else?
Nothing further on my end, Your
All right, thank you. Have a good day.
Thank you.
Carrizales, can we have Ms. Garcia, please?
Yes.
She's on already. You can verify the paperwork.
Okay, Ms. Dora. Sorry, Ms. Dora Garcia?
Yes, ma'am.
Has your attorney thoroughly explained these documents to you?
Yes, ma'am.
Do you have any questions for your attorney at this time? Ma'am, do you have any questions for your
No,
attorney
ma'am.
at this time?
No, ma'am.
Okay. And can you confirm that this is your signature?
Yes, ma'am.
I'm gonna go ahead and do it for your next case as well. Has your attorney thoroughly explained these documents to you?
Yes, ma'am.
Do you have any questions for your attorney at this time?
No, ma'am.
Okay, and can you confirm this is your signature as well?
Yes, ma'am.
Okay, thank you.
Julieta?
Present.
Hi, Miss Julieta. This is our last defendant and she speaks English, so you can go to another court if you need to.
All right, that's fine.
Thank you so much. Ms. Garcia, raise your right hand, please. Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you. You can put your hand down.
Hey, who are you? Who is that?
She's filling in for Brenda.
Oh, okay, hi. What is Mr. Rincones, what is Ms. Garcia pleading guilty to in 2020 DCR 1232? Are they all thefts?
No, Your Honor. One is a theft and the other is a possession of controlled substance, Your Honor. Both of them are state jails.
Which is which?
Let me check real quick.
The 1232 is the theft and the other one is the possession.
That's correct, Ron.
1232 is the theft?
Yes.
Okay. Thank you. All right. This is cause number 2020 DCR 1232, State of Texas, Dora Celia Garcia. Is that the true and correct name?
Yes, sir.
Your attorney tells me you wish to enter a plea of guilty to theft in this cause number. Is that correct?
Yes, sir.
Are you aware that that is a state jail felony which calls for confinement in a state jail facility for a term of not more than 2 years or less than 180 days? In addition, I can impose a fine not to exceed $10,000. Are you aware of that?
Yes, sir.
Are you doing this freely and voluntarily?
Yes, sir.
All right. Also in cause number 2021 DCR 625, State of Texas versus Dora Celia Saldivar, Dora Celia Garcia. What is your true and correct name?
Dora Celia Garcia, sir. I'm married now.
All right. And I understand that in this cause number, you're pleading guilty to possession of a controlled substance,
Yes, sir.
and that's also a violation of a state jail felony which calls for confinement in a state jail facility for no more than 2 years or less than 180 days. In addition, I can impose a fine not to exceed $10,000. Are you aware of that?
Yes, sir.
All right. Are you doing this freely and voluntarily in this case?
Yes, sir.
All right. Is it necessary to rearranger in either one of these cases, Mr. Lincoln?
No, Your Honor, we waive.
All right. Understanding what you're pleading guilty to in cause number 2020 DCR 1232, the theft, understanding what the range of punishment is. I'm now asking that cause number, what did you plead to the charges of theft, state jail felony? Guilty or not guilty?
Guilty.
All right. In cause number 2021 DCR 625, understanding what you're pleading guilty to, possession of a controlled substance, understanding that it's a state violation of state jail felony. I now ask you, what did you plead to the charges of possession of controlled substance? Guilty or not guilty?
Guilty, Your Honor.
Are you a citizen of the United States?
Yes, sir.
Are you pleading guilty to both of these charges in this respective indictments because you are in fact guilty of both of these things, of theft and possession of controlled substance, respectively?
Yes, sir.
Because you're in fact guilty and for no other reason.
Yes, sir.
All right. Are you pleading guilty to any of these charges out of any persuasion of fear, hope of pardon, force, threats, or promises of any kind?
No, sir.
Have you ever been in a mental hospital or treated by a doctor for any mental disorders in either one of these cases?
No, sir.
Mr. Rincon, do you find Ms. Garcia competent, able to assist in a defense she may have
Yes, I do, Your Honor.
in both of these cases?
Yes, Your Honor.
What is the plea agreement in 2020 2020 DCR 1232.
As to both cases, Your Honor, in exchange for a plea of guilt, the state is recommending 15 months in a state jail facility. They are to run concurrent and receive credit for time served.
All right. Ms. Garcia, do you understand that this plea agreement, the recommended sentence is something that it's only up to me whether I'll accept it or not? Do you understand that?
Yes, sir.
If I reject it, I will allow you an opportunity to withdraw your plea of guilty and proceed to a jury trial in both cases or in one case, whichever one I reject. Do you understand that?
Yes, sir.
If I accept it the way it's been stated and the way you expect it, you may not appeal your case without the court's permission, except as to pretrial motions that Mr. Rincones may have filed on your behalf prior to today in both of these cases. Do you understand that?
Yes, sir.
All right. In that case, I'm going to find that your guilty pleas in both of these cases are freely and voluntarily made, and you're competent to stand trial in both of these cases, and ask the state to produce evidence to substantiate the plea in 2020 DCR 1232.
State offers 1, 2, and 3 into evidence.
No objection, Your Honor.
I also have the state to produce evidence to substantiate the plea in 2021 DCR 625.
State offers 1, 2, and 3 into evidence.
No objection, Your Honor.
Ms. Garcia, I have in front of me 2 plea packets. They are both involving the cases you're pleading guilty to. These are all documents related to your arrest and your processing in each one of these cases. In 2020 PCR 1232, your plea packet consists of 3 exhibits. Exhibit number 1 consists of 8 pages, and on page 6 of exhibit number 1, there's a signature line. Is this in fact your signature in this case in 1232?
Yes, sir.
All right. And in cause number 2021 DCR 625, your plea packet also consists of 3 exhibits. And also your exhibit number 1 is 8 pages, and on page 6 there's a signature line. Is this in fact your signature in that case?
Yes, sir.
Are you aware, Ms. Garcia, that in this, upon signing these documents, and in these documents, you're giving up your right to your right to a jury trial, your right to remain silent, your right not to incriminate yourself, and your right to confront your accusers? Are you aware you're giving up those rights in these documents?
Yes, Your Honor.
And further, Ms. Garcia, in both of these documents, with respect to exhibits 2 and 3 attached to the respective cases, are you agreeing that you have stipulated with the state that exhibits 2 and 3 attached to your respective cases are true and correct copies of the original offense reports, lab reports, incident reports that were generated as a result of the respective arrests in both of these cases, and the reason you're pleading guilty to both of these cases this morning? Is that in fact your stipulated agreement now?
Yes, sir.
All right. So in that case, I'm going to find as to both of these cases that you have voluntarily and intelligently waived your constitutional and statutory rights, and the evidence offered by the state that substantiates your plea in 2020 DCR 1232. And accordingly, the court will find you guilty of theft in that case. And also the court will find that the evidence substantiates your plea in 2021 DCR 625, and the court will accordingly find you guilty of possession of a controlled substance state jail fund in that case. What is Mrs. Garcia's background?
Got a misdemeanor DWI, 2 misdemeanor prostitution, a failure to ID, and 2 misdemeanor thefts.
The reason why sentence should not be imposed.
None, Your Honor.
None, Judge.
In 2020 DCR 1232, is the order judgment decree of this court that you be taken by the sheriff of this county, that you be transferred to the authorized representative of the Central Division, Texas Department of Criminal Justice State Jail Facility, where you should be confined for a period of 15 months. You will receive credit for time anytime you've served in jail awaiting discharges. And further, in cause number 2021 DCR 625, it is the order judgment decree of this court that you be taken by the sheriff of this county, you be transferred to the authorized representative Judicial Division, Texas Department of Criminal Justice, where you shall be confined for a period of 15 months. Your sentence will commence this day. You will be given credit for the time you have spent in jail awaiting discharge. Further, the court will not impose a fine on either one of these cases, and the court will run them concurrent. All right, anything else, Mr. Licone?
Nothing further, Your Honor. That's all I have. May I be excused?
Have a good day.
You too.